That really, really sucks. I mean, really, really.
There shall not be any cutting of trees. Don't cut any trees. I'll pass the order. No cutting of trees, no felling of trees in Patta number 12.
Well, hello, everybody. It is Artie of Artie's Corporate Fiction. Yes, we have breaking news. I got an email from Alex, and it obviously spread like wildfire to others.
Hello, this is Attorney Mike Graham coming to you from Chicago, as usual. And the day's finally come that we all suspected would come. Looks like Chille went too far. From my perspective, he's gone too far for years. But it looks like it's finally caught up to him. What I'm going to do right now, I don't have the clip unless somebody tells me where it is. I'm waiting for our Nevada judge's version of it. I have on good authority that's coming out soon, namely Alex. I also have on good authority that it did not go down well.
I went in front of Judge Zimmerman again, and she had already decided that I wasn't going to give my appeal on. And, you know, for Ms. Zimmerman, what she doesn't understand is that I really have fundamentally changed my perspective. She may not know that because she only sees what she sees on video, you know, the way I am with my bravado. But obviously, after losing in Arizona, losing in Massachusetts, losing in Ohio, and now losing in Nevada, the common denominator there is me. And so when I go to court, I have to change the way I have been, or I'm just going to continue to lose. I'll just continue to lose over and over and over again.
Yeah.
So where Ms. Zimmerman was incorrect was that I unfortunately, I've had 2 weeks of just completely being, you know, in this position like this where all you have time to think. So I have changed, and I want to advise anybody else who ever hears me that you should not behave the way that I have done in court in 4 different states, and I've lost in 4 states. So obviously, the problem is me, and so I have to change the way I am. Continuing on that idea, as I move into public life, I have to change the rhetoric that I use.
Today is a glorious day here at Team Sketzer. Now, before we get started, I'd like to give a special shout out to our Nevada judges, which is the YouTube channel that's responsible for bringing us this timeless classic. Because if it wasn't for him, we wouldn't have video footage of a going to jail. Now, we have 2 videos to cover today. So welcome to Amsterdam, and let's begin.
I was afraid for a second the judge was going to cave and be like, oh, I feel bad for him, and do all this routine. I really did. And when she starts in with, have you seen the stuff he's putting out there? I'm like, oh, this isn't good. This isn't good for him. His attorney did a fantastic job. He said, hey, we've got some First Amendment issues. I appreciate that you don't say it that way, but I think we have some First Amendment issues. We want to appeal this. Can we get an appeal bond? Those are all appropriate sorts of things. If he would have let somebody like this attorney talk for him instead of run his own mouth, he might be in a lot better shape right now. In fact, I'm confident that he would be in a lot better shape right now. So his attorney did a nice job under the circumstance. I thought it was extremely professional. Extremely well done. The judge also was not backing down. I saw this from the get. Like, look, I sentenced this guy for half of what I could have sentenced him for. And I'm sticking with it. The prosecutor, the only time I've ever seen her is on this case. She's good too. She wasn't backing down a bit. She's like, usually I get 10 days to respond to this, but I can do this. I can do this right now.
That was gratifying. I don't know about you guys, but man, smoke them if you got them. Am I right? All right, we're gonna stop here. Embrace the Schadenfreude.
Good afternoon, everybody. My name is Scott Coffey. We are here on Our Nevada Judges, and I am your host. We've got an interesting topic today. We're going to be talking about the First Amendment, what happens when it runs into the police's ability to do their job on the scene, and we're going to be talking about Jose de Castro, who is currently serving 6 months for obstruction and resisting in what started as a filming incident at a traffic stop. He calls himself a constitutional law scholar and says that he is providing a public service by documenting police activity, and things kind of escalated. We're going to talk about that case, and I am happy to have two guests with me today. We've got Lisa
Zick.
Zick.
Yes.
I didn't want to mispronounce that. And Anthony
Bandiero.
Mr. Bandiero does training for Las Vegas Metropolitan Police Department.
All the agencies here. I teach pretty much every agency.
Yeah, has for years. And Ms. Zick is a criminal defense attorney.
Yep.
As am I, but we promise we're not going to tag team Mr. Bandiero on this. We're going to have a
That's all in the
open
middle.
discussion.
Yeah.
So, Mr. De Castro, you've had the opportunity to watch the trial and the video, both of you. What were your initial impressions?
So initially, I thought that the arrest should have never occurred. I think that he was not obstructing. And I think it will be interesting to see what Judge Levitt does with it on appeal. I think that he has created some interesting issues with his courtroom antics and post-conviction behavior, but his behavior on the day, at the time, the filming at the traffic stop, I don't think it rises to the level of obstruction.
What's an officer to do, though, when they've got somebody who is in their face and confrontational? And we can agree, Mr. De Castro seemed to be somewhat confrontational, right? Go back and do your job, little doggy.
Sure.
Those kind of comments.
But if you, but first I want to address the comment in your face. Is 10 feet really in your face? He was, the court record indicates that he was 10 feet away. Is that in your face?
It's a good question. How close is too close?
So first of all, I want to say that, my views are just mine. I do teach a lot of agencies here, and this issue is still being litigated, and one of my clients is involved in this case. But I will say this is that this is a tough situation. I mean, these police officers are tasked with a very tough job, and, officer safety is a legitimate safety concern. But we also don't want to, hyperbole, right? We don't want to think that everybody is out there to kill us. That's not a good mindset either. That's actually a very unhealthy mindset. How close is too much? I will say at the end of the day, what I teach my officers is that when it comes to obstruction, is that you basically cannot effectively do your job. And I compare that with efficiently, right? A lot of these First Amendment auditors will do things where it causes you cannot efficiently do your job. You have to, talk a little louder. You have to, maybe, take your attention away and maybe address them for a little bit. That's not so efficient, but it's also maybe not illegal. I'm not saying we haven't really got to the brass tacks of what Jose's done in this case, but I'm just saying that's generally speaking, how close is too close? The officer, what I teach and my principles is that the officer cannot effectively do their job.
And you say First Amendment auditor. What is a First Amendment auditor? This is a newer term. I mean, I've done this job for 30 years.
Yeah.
This is the first time I've heard that. Maybe I need to be more in tune with social media.
So interestingly, I, in preparation for us to have this discussion, did a quick little, search on Google to see, because there are lots of definitions for that phrase, because it is a relatively new phrase. And there are two prevalent internet definitions for what is being defined as a First Amendment auditor. One is exactly the behavior that Mr. DeCastro is engaging in, those that pull out their phones and record police activity. And another is people who pull out their phones and record activity in any public space. So it goes that beyond that of a just police activity. But if I walk into a commercial business and I pull out my phone and start recording interactions between a patron and a customer, if the employee at that business calls the police on me, they have failed essentially that First Amendment audit, because the argument is that you should be able to record any interaction in any public space. That puts us down a completely different rabbit hole than from today's conversation. But I thought it was an interesting point of view because it kind of ties into, I think, Mr. DeCastro's point of view and where he was at when he was recording the police interaction in the traffic stop.
So is the position of these folks that in public spaces there is no privacy?
Essentially, yes.
Generally.
That's the idea, and particularly with officers. Of course, officers have body cam now.
So they're recording themselves. But I would also say, just before we go on to that, because I think that there are actually two types of First Amendment auditors. There's the first 1A auditor, want to be cool about it, you know? The first 1A auditor is those who just want to record. They just want to see police officers. They're actually hoping for a good outcome. They're hoping that the Constitution is complied with. And then there's the other First Amendment auditor who's like Castro, who is really after three things: money, badges, and fame. They don't want to just watch cops succeed. They want to watch cops fail. And the way he acts, what he says, the words he used, you know, go back to your job, little doggy, whatever, you know. I mean, he says all kinds of things. He does not want to see cops succeed. Yeah, he's actually makes it very clear that he is very anti-police. And I just want to be clear that that's something to consider. But generally speaking, it's not illegal to record police officers in a public place doing a public act,
or to be anti-police,
or not to be anti-police. Absolutely, he absolutely has the right to be anti-police. Absolutely, and he has the right to say that during his presence.
But in this situation, there's no question he's antagonistic.
Correct.
Right? He doesn't want to back down. He's at another arrest where he was also antagonistic.
Right.
Told an officer, "Shut your mouth. I'm an important guy.
Right.
I'm on YouTube, and you're going to look like a fool. Just shut your mouth and mind your own business. You know what's good for you."
Right.
I mean, he is clearly antagonistic.
And he's good. He's very good at it, by the way. If you watch his videos, he's highly effective. He's sharp when it comes to this antagonism.
Being antagonistic doesn't always rise to the level of being a crime. I mean, in this case, I realize that argument sounds ridiculous because he was arrested and now sentenced for obstruction. But had he been 20 feet back, would we be having this conversation?
I think the key, though, is it's not that he's committing a crime by being antagonistic. I think it's that you have an officer who is allowed to consider his antagonism. He's allowed to consider that this person clearly does not either see me as a legitimate authority or whatever, and he's allowed to consider that part of his officer safety issue.
Understood, but in this instance, part of this is whether or not you're stopping an officer from doing his job, right?
Mm-hmm.
That's part of the.
I think so.
Part of the fundamental definition, I would think, of obstructing. And in this instance, before DeCastro is ordered to go to the police car, he lets the motorist go.
Right.
His job is done at that point. And the resisting's about the walking to the police car, which DeCastro's doing. He's disgruntled about it, but he is doing it. I'm a little. It seems like we're having it both ways to some extent. If that makes sense.
The only thing I will say about this, and I love your point of view on this, is that at the end of the day, if we believe that a crime has already occurred, that he's already obstructed, which we can debate about that, then he's allowed to now have discretion. So you know what? I have a bigger fish. You're my small fish. You were just committing a very minor traffic violation. In fact, it was like registration issue. You're out of here. Now I'm going to deal with him.
Sure. But what would the normal everyday obstructing, would it always result in an arrest?
No.
Again, well, it's discretionary, right? And so many years ago, I had a case that was kind of similar to this, where it was a traffic stop and it was a sovereign citizen case, which, again, another rabbit hole. But officer asked my client for a driver's license. He didn't have it because he had a constitutional driver's license, and it led to an obstruction and a resisting charge because my client couldn't produce a driver's license. And so ultimately, as my client was shuffling through these papers trying to find his constitutional driver's license, the officer felt like he wasn't complying with the command fast enough and ultimately pulled my client out of the car, which led to the obstructing and the resisting charge. So in my mind, I don't think there's much of a difference between my client attempting to produce his constitutional driver's license and what Mr. DeCastro was doing in this case. He was standing 10 feet away, yelling obscenities at an officer. By the time he got to the point where he was walking to the car, we have compliance.
Right. So, I mean, it is a very interesting question as to where the ability to film First Amendment rights run against officer safety, officers' ability to do their job. I mean, a cynic here would say DeCastro got arrested for being a jerk, not DeCastro got arrested for anything he physically did. Because there's a real question whether there was any physical obstructing in this particular
There's a legitimate
instance.
question. I think that's something that should be viewed on appeal, right? I think that's not something that actually really got into at the trial level.
I would agree with that.
Yeah, that's probably a missing ingredient for me, at least. I would like to know that because I would like to talk to you about the Wilson case that's come out recently that may help define whether or not DeCastro is violating the law and so forth, obstruction.
Yeah, and tell us about Wilson.
So real quick, so Wilson, I wish I knew if it came out. I think it actually came out before DeCastro's trial. And I'm almost positive of that, but I can't quote it. But basically what happened is Wilson is a lady in Carson City. She is observing a police interaction with a suicidal juvenile. And I'm sure it's very tense. According to the case, the kid had a knife to his body. I'm probably thinking throat, right? And he's suicidal. So Carson City SO Sheriff's Office is trying to get him in custody for what they like a civil commitment because he has to go get checked out. And throughout the whole time, Wilson, for whatever reason, is yelling at these police officers. I don't know if she maybe disagrees with their tactics, something about it she doesn't like, but she's targeting the officers. They tell her multiple times to, hey, police, stop yelling at us. We're trying to focus on this poor kid. You're obstructing us. She will not stop her behavior. And at the end of the day, they did get the kid in civil, in custody, civil commitment. They then went to her and said, Wilson, you're going to get a ticket, right? You're going to get arrested or not arrested, cited for obstruction. And she goes to trial. She loses. And it goes because, she is taking away the officer's focus, right? The officers, in a sense, cannot do their job efficiently when they have somebody like Wilson yelling. We all agree on that. So it goes to the Nevada Court of Appeals and they say, hey, timeout. That's not really what obstruction is. Just because you have a person engaged in the First Amendment, what was her intent? If you look at the NRS, what was her intent? Did she willfully try to delay, obstruct, hinder? No, not that maybe, but you haven't proven that. All you said was that in the trial court was looking at, did it have the effect of delaying their investigation? Yes. But what is her intent? Was that her willful intent, or was she just willfully trying to speak her mind?
Which brings up an interesting question in this case, right? Because DeCastro claims he's doing a public service.
And he definitely believes that.
And that he's a member of the press.
Correct. Right? He is. Legally.
He?
Oh, absolutely.
Okay.
Yeah.
100%. Without a doubt.
I agree with you. Explain why.
Well, because the whole freedom of the press does not, it's clear under case law that the freedom of press is not just Fox 5. It's every person who's trying to gather information or give information about public affairs, about things that are public interest. And that's what he.
And I watched some commentary on the case, and somebody was complaining that he was claiming to be a member of the press. Well, that's ridiculous. But the fact of the matter is, he has 500,000 followers. 500,000. That's more than circulation of the RJ, I guarantee.
Yeah.
Sure.
More than circulation of a lot of papers.
Yes.
And so there has to be an outlet, I suppose, for those sorts of activities too, even if they're not Walter Cronkite,
and that's
Eduardo Murrow.
I think my issue is with the use of the word press, because I think he is a sharer of information. I don't think that press to me implies that it is
real, like traditional. Like
I would call him a vlogger. I would call him.
That's the press, though. You can give him that. Yeah, absolutely. I mean,
you're not taking the position that the press is necessarily objective now, because I think we've seen a move away from that.
No,
I'm
from
not.
Both
sides,
but I don't. Again, I have.
He's not super legit.
Yes.
Right.
Yes. Like he's not. I would not. Like he's not getting a press pass to go into a news conference.
No.
Yeah.
And what would stop anybody from any private citizen to pull
She's
out the
wrong.
funds
It's a
and
matter of
right?
constitutional law, Carmen.
Yes, I think there needs to be a distinction there. Although I don't disagree with you that he has some legitimacy.
it's,
with his 500,000
What you said,
followers,
constitutional driver's
but I
license
don't know
earlier?
that I could go so far
What
as
is
to call
that?
him a member of the press.
Get a
Well,
South
he's
Not traditional press. I agree.
he's certainly self-aggrandizing. Right?
Sure.
Yeah.
Yes.
He is certainly pats
You
himself
can
on the back
substitute
every chance he
imaginary
gets.
He
driver's
definitely does that
license.
both hands.
For constitutional
And
driver's
certainly,
license. I think
he
they're
certainly is in the face of
interchangeable.
authority. But
Sure.
the flip side is we don't have people that are willing to do that. We don't see the video on George Floyd.
Yeah.
We don't see Rodney King 25
No,
years ago.
he's
They're all
performing a service. I
And,
do agree with that.
and it falls under the
And
First
he
Amendment.
has
And
a
it falls under the First
large, I do agree with
Amendment.
that.
Yep,
And he has a large audience. So I can agree with all of those things. My issue is just.
yep. Yeah, he can go into the White
press.
House.
Yeah.
He can be part of the press corps. I agree with that.
Yeah.
the flip side of this, though, if setting aside the taping portion and everything else, what does this case say about how to handle yourself or not handle yourself in a courtroom?
Hell yes.
Right. Okay.
That's a funny one.
So interestingly, I think that actually raises a completely different issue because so judges set the tone for what is appropriate courtroom decorum, right? Like, and we've seen it in many courtrooms besides just Judge Zimmerman's. Like, I myself have seen my own clients be taken away by multiple marshals in which I've had to put my hands up and step away from the table because they have not liked the sentence that has been rendered on them. I have also seen my clients slam on the table and scream obscenities in the middle of trial because witnesses have said testimony that was not true. Client control is real for defense attorneys. I don't have to tell you that. But I think what he did here was just part of the persona that he portrays. Whether he believes it or not, or it is a persona, I don't know. But whatever those were antics. And perhaps for clicks and views and clickbait. It did not help his position in any way.
Well, it certainly got him more punishment,
Sure.
right?
Yeah.
But it also drove people to, I mean, I've seen the trial views. There was something like 500,000 trial views. for this.
Again,
Something
clickbait.
crazy. So the punishment, he got 6 months.
Max.
For
The
this.
max.
She was, in my opinion, Zimmerman punished him for his behavior in the courtroom, not for his citation. Because how many times have you defended an obstruction citation and it has been 30-day suspended sentence, go take an impulse control?
Well, one of the most interesting things to me about this whole trial was Agus Botello, the prosecutor, asked for a $500 fine and a suspended sentence.
Yeah.
Sure.
But when's the last time you've had a prosecutor come in and ask for a fine, nonviolent offense, and the judge says, you know what, I think I'm going to give you 6 months in custody? That is a rarity, I would imagine. In my 30-year career, I've never had it.
I've seen it happen once. And again, in that moment, that was when my client slammed on the table and started screaming obscenities, where the judge went sideways on my sentence.
Yeah.
But again, my client had behavior that was similar to Castro's in the courtroom.
But judges also have other tools to deal with that, right? Contempt of court.
Sure.
But contempt of court's only 25 days.
Yes.
So
And well, contempt of court is a little bit, you have to consider it has to be a violation of a lawful order. And did she tell him to stop? Did he commit? And because there are two things to consider with contempt of court. One, the egregious behavior has to happen in front of the judge, which in this case it did. And two, there has to be an order. So did she order him to stop and then he did it again? Or did he just have an outburst and she got tired of it?
For the viewers, should we actually say what the egregious behavior? Because
Yeah.
I think it's important for our viewers to understand
Absolutely.
what we refer to. And I'll say it. He basically the judge said that no phones were allowed to record. There's only one organization allowed to record. I think it was our Nevada judges.
Yes.
what?
And
They properly
they
filed a
properly
media
did it,
request.
and so he did not. But she's not stupid. She knows that he's probably surreptitiously recording. I think he was actually, if that's what I heard. Regardless, she wanted the marshal to hold onto his phone, which is appropriate because he is a chronic, surreptitious recorder. And he basically gave the phone to the marshal. And he said something like, "You pig."
Yeah, or little piggy or something.
Yeah, something like that. But clearly insulting. That the marshal did nothing to this guy, just doing his job, commanded by the judge. The judge obviously was not going to accept that.
Yeah, and in my experience, insulting court staff is about the worst thing you can do.
Absolutely.
It's akin with it had he said it to her. But where I have
You're
to
right.
give Judge Zimmerman credit, when she made her sentencing record, she made a very clear record for the basis for this maximum misdemeanor punishment. That I think, if you look at it on its face, will make it very difficult to overturn this on appeal, because she appropriately justified it.
His behavior, his chronicness of he also has a pending
Well,
case.
What
Yeah.
what she said, it was officer safety, and she was concerned about officer safety. Do you think that's honestly it? I mean,
For the sentence?
That's a tough question. I know what she said on the record.
Sure.
Okay. But I got a pretty good feeling what he's being punished for, and it's not for violating officer safety.
The question is this. I think the question is this. If you had a guy who was within 10 to 15 feet, because I think he backed up a little bit. If you had a person 10 to 15 feet simply doing this and got arrested for obstruction, would he get 6 months in prison? I'm sorry, jail. Probably not.
No. But also, if you had a guy at 10 to 15 feet and he was simply doing this, does he even get the citation?
Does he even get contacted? I don't know. I think that I told you the aggression is going to be part of the calculus, right, for the officer, and I think that's fair.
And I think if you have the guy who's 10 feet out and follows the command the first time where the officer says back up, and all he does is still stand there and do this, we never have this case, we never have this conversation, and you have a guy who doesn't have 500,000 YouTube viewers, right?
No.
Because this is boring, and this doesn't get clicks.
Anthony, you've done training for
Everybody.
decades.
Yeah, a couple decades, yeah.
Long time.
Yep.
I would imagine the training on how to handle these First Amendment auditors, these sort of things, has changed over the last 20 years.
Not only has the training changed, actually the training it used to be non-existent. It's the officer's mentality has changed. I will tell you that, if you look back 20 years, officers were falling for these First Amendment auditor audits left and right. They were basically being, they're just falling for, literally falling for it, because it's a trap. A lot of these guys, like the cashier, they want to see these officers lose their cool
And engage.
And then when I see officers and I'm not saying here wasn't right. I'm just saying in general, when you do see officers that don't bite the bait, you don't get any views, or you don't see the video at all. But we do see, since about 20 years ago from today, you do see less and less officers actually engaging these people, because they actually know that they're being played, right? That's really.
But that also rises to the level of, going back to your hypothetical just a second ago, you have the guy at 10 feet, 15 feet, he's standing there, and again, he's screaming the things at the officer, but he's not in any other way obstructing, or he's even 15 or 20 feet back, and he's standing there and still yelling the obscenities. Again, being anti-police is not a crime. Saying things that might hurt your feelings is not a crime. If he's not willfully or intentionally interfering with the officer in the engagement of his lawful duties, we haven't committed a crime.
But I will tell you what I tell my clients time and time again. They will complain about the officer was rough with me, or whatever might happen. He doesn't have a right to do this, or he doesn't have a right to do that. And I say, next time you get in a beef, you take a copy of the Constitution and you hold it up and you see how well that stops a baton or a boot to your head.
Yeah, because it still hurts when you get hit.
It still hurts when you get hit. And the fact of the matter is, if you are antagonistic, you increase the chances of getting confronted, getting arrested, getting injured exponentially.
And they're human beings. Just like Judge Zimmerman's a human being. If his behavior contributes to his sentence, it is what it is. It's part of being a human being, right? And people do have reactions to this thing. The one thing I'd like to address though is DeCascio was not just filming and being antagonistic. He was also engaging the driver. Does that play any role for you in the officer's contact with him?
Yes, because at that point it adds a level of maybe then he's rising to a level of interfering.
Right.
But did it stop the officer?
Right.
Because was the officer still able to write his citation? Did the officer even write the citation, or did the motorist just drive away? Because to me, if I stand there and yell, and unless what DeCastro was yelling was, you don't have to answer his questions, you don't have to show your registration.
You can drive away.
Yes, unless DeCastro was saying any of those things, which is bad legal advice, he's not obstructing.
Wait, well, the bad legal advice is a whole different issue for this particular person, right? Because he says one of the ways that he makes money is selling legal documents online.
Right.
You have to wonder the value of those
the
documents.
unauthorized practice of law.
Yeah, I probably wouldn't buy those documents, but
sure.
But there's a market for it. right?
Oh,
That's
yeah.
why he has that many.
Well, your
views.
sovereign
less than
citizen
the
client had a
tribe
license probably sold by the cashier.
Yeah.
It was 15 pages.
Is this happening? Is this on? Does it sound like Donkey Kong?
Page 1, Deborah Jean Trope, C376548. We have it. Okay, good morning.
Good morning.
We got a copy of the proceedings, and we have a copy for you, so I'm just gonna ask them.
Were you able to get the tape?
I need 2 different ones. Okay, they're 2.
Good afternoon, everybody. My name is Scott Coffey. We are here.
Tell you that, if you look back 20 years,
Uh-huh.
officers were falling for these First Amendment auditor audits left and right. They were basically being, they're just falling for, literally falling for it because it's a trap. A lot of these guys, like the cashier, they want to see these officers lose their cool
And engage.
And then when I see officers and I'm not saying it, I'm not saying here wasn't right. I'm just saying in general, when you do see officers that don't bite the bait, you don't get any views, or you don't see the video at all. But we do see, since about 20 years ago from today, you do see less and less officers actually engaging these people because they actually know that they're being played, right? That's really.
But that also rises to the level of going back to your hypothetical just a second ago. You have the guy 10 feet, 15 feet. He's standing there, and again, he's screaming the things at the officer, but he's not in any other way obstructing, or he's even 15 or 20 feet back, and he's standing there and still yelling the obscenities. Again, being anti-police is not a crime. Saying things that might hurt your feelings is not a crime. If he's not willfully or intentionally interfering with the officer in the engagement of his lawful duties, we haven't committed a crime.
But I will tell you what I tell my clients time and time again. They will complain about the officer was rough with me or whatever might happen. He doesn't have a right to do this or he doesn't have a right to do that. And I say, next time you get in a beef, you take a copy of the Constitution and you hold it up and you see how well that stops a baton or a boot to your head.
Yeah, because it still hurts when you get hit.
It still hurts when you get hit. And the fact of the matter is, if you are antagonistic, you increase the chances of getting confronted, getting arrested, getting injured exponentially.
And they're human beings. I mean, just like Judge Zimmerman is a human being. If his behavior contributed to his sentence, it is what it's part of being a human being, right? And people do have reactions to this thing. The one thing I'd like to address though is the cashier was not just filming and being antagonistic. He was also engaging the driver. Does that play any role for you in the officer's contact with him?
I mean, yes, because at that point it adds a level of maybe then he's rising to a level of interfering.
Right.
But did it stop the officer?
Right.
Because was the officer still able to write his citation? Did the officer even write the citation, or did the motorist just drive away? Because to me, if I stand there and yell, and unless what DeCastro was yelling was, you don't have to answer his questions, you don't have to show your registration.
You can drive away.
Yes, unless DeCastro was saying any of those things, which is bad legal advice, he's not obstructing.
Well, the bad legal advice is a whole different issue for this particular person, right? Because he says one of the ways that he makes money is selling legal documents online. Right. You have to wonder the value of those
the
documents.
Unauthorized practice of law.
Yeah, I probably wouldn't buy those documents, but
sure.
But there's a market for it, right?
Oh,
that's why he has that many.
Well, your sovereign citizen client had a license probably sold by the cashier.
Yeah.
It was 15 pages of the Constitution.
Yeah.
That from Pennsylvania.
I mean, I look at it from the officer's point of view, though, right? I mean, there's something we said about the officer's in his squad car. He's looking this driver up, and he sees a random person engaging his driver with the phone and so forth. What do you, if that was you, if you were on the receiving end of a DeCastro, wouldn't you want the officer to push this guy back a little bit?
I mean, yes, but for safety reasons of myself. I don't want some random stranger standing at my window. But also, as a criminal defense attorney, my window is only rolled down this much because you don't need to hear anything more than my eyeballs.
But you change the fact, change the answer. What happened with
you're not wrong.
Right? That's true. In this case with the female driver that was here, she rolled down her window completely. She was DeCastro only 5 feet or so away from her, maybe 10. So, right, I mean, there's something to be said about that, where the officer can say, hey, maybe it's not just my safety or my investigation, but it's also her. And he actually did say that in court, that she had a right to privacy. Now, of course, we gotta be careful with that, right?
Sure.
I mean, but I know what he means. Obviously he's not a lawyer, but what he means is, hey, I got to protect. He did say something like this. Responsible for her, and he is.
Well, he's essentially saying what Castro said in the other stop, which is mind your business, right?
Mm.
He got directly in the officer's face, mind your business.
Right, exactly. But it is his business.
It is his business.
That's his detainee. She is seized because of the officer's action, so he's responsible for her.
But she wasn't under arrest, so she's not a detainee.
Well, you know what I mean.
I mean,
She's detained. She's seized under the 14th
She's
Amendment.
stopped.
Yeah, she's not in custody. But the point is that he is still responsible in many ways for her safety and so forth. Now, I'm not saying.
But there was nothing there at that point that gave rise to the level of that was a threat. Like to Castro with his phone in his hand isn't rising any alarms that there's an imminent threat.
Other than generically, everybody is to some extent, right? And I would imagine as an officer, you are trained to some extent to say the worst threats are the ones that you don't see.
Yeah, and I do want to be careful though, because if we go down that road, then everybody's a threat. You're a threat right now, and I can put you in handcuffs. I mean, everybody could be. I could be a murderer. It's the point is, anything's possible. It's just not probable. So we want to be kind of careful with that hyperbole and that we call it hypervigilance.
Sure.
And it can cause bad things.
But it's very interesting to me looking at the two different stops. The one that he was convicted for, the other one I think may still be pending.
Yeah.
The officers use different tactics, right?
Mm-hmm.
The officer in the case where he's convicted, pushes back pretty hard. Get over here. You're going to do what I say. You're going to do this. The other officer's older, seemed more experienced. It was a vehicular death scene.
It was a fatal accident involving, Metro motor officers.
And there he was way out of line, in my opinion.
He was really pushing it.
He was underneath the police tape, back outside the police tape, going into areas that he shouldn't be.
Yeah.
But the officer was much calmer about things.
Yeah.
They didn't listen to his mouthiness, which got to be hard.
Yeah.
And nobody's going to say that's easy, particularly if you're out there by yourself.
Sure.
But it de-escalated in a very different way.
Yeah.
But officers are human.
Yep.
So how much of this is attributable to training? What are officers trained as far as being assertive, that sort of thing?
Well, look, I mean, the DNA of an officer is to be in command, right? I mean, that's from day one in the academy, they are taught to take control of scenes. And that's what you want. You think about October 1st and everything below that. I mean, you can't have an officer who's not assertive and in control. But the other thing is, of course, the part of the training is don't forget the Constitution, right? I mean, it's not a recommendation; it's a mandate, and people have rights. So at the end of the day, make sure your orders are lawful, and that's what we're talking about here. It was the order to back up lawful. Did he back up enough? That's the question that I would love to see what the appellate court, finds, right? Because
I can be assertive without being an asshat.
Yeah, sure, I agree. That's what you're talking about.
Yeah.
And I think that's the difference there, because in the situation where he was under the police tape and the fatal, when death is involved, there is a level of respect I think that's required in any situation, right?
Mm-hmm.
And so at least to me as a human being, when someone has lost their life, there is a level of respect that I think the situation warrants, no matter the circumstances. And I think the experienced officer in that situation absolutely handled it correctly, in taking every step to de-escalate, minimize, but still I think he was also in command, just without having to raise his voice and show his muscle.
Metro officers are definitely highly trained in de-escalation. Could he have done a better job? I think everybody can do a better job, but overall, I mean, I didn't see something too egregious. He wasn't yelling at the guy. He wasn't threatening him. He was just saying, get back, you're obstructing and so forth.
How about the grab when he's walking to the car?
So, here's my thing. I think that my viewpoint has always been, even if the order was unlawful, even if he, per the law, looking in retrospect, he was back far enough. My view has always been that when officers, are going to put hands on you, you comply. And first of all, it makes sure that everybody survives the incident, right? Because, we know that when people resist, even if it's an unlawful arrest, people can get hurt. And usually it's not going to be the cops, right? Cops are the ones training to have the bat belt. They have all the tools. So I think my viewpoint is him resisting and him pulling away, if that's what actually happened. Again, I wasn't there. The video is not super clear on how much resisting he did. I do not think that was, I think that's unlawful. That's what I think.
And the officer even said, I didn't think he was trying to
hurt me.
Right. Didn't think it wasn't that kind of situation.
Yeah. Just be non-compliant.
just non-compliance. You
Right.
keep your hands off me. I'm following your orders.
Right,
And
right.
he appeared to be following orders at that point.
Generally, maybe not perfectly, but but we'll see, right?
Yeah. No, it's
And well, so what's interesting there too is again, you have to look at the resisting statute because legitimately, maybe not perfectly is about as clear as mud. And so I think there you'll see a situation similar to maybe the Wilson situation because I think we have an issue with how our obstruction and our resisting statutes are written because they leave a lot of room for interpretation. And when you're actually trying those cases, it becomes a problem because it leaves a lot of room for interpretation.
I was a cop in Nevada, and I basically joked like obstruction was always the catch-all. Like if you committed a murder and you weren't sure what type of murder, just end with obstruction. We'll figure it out later. That Wilson case, that's one of the reasons I wanted to get on the show because I really want to say like I would love to for the judge. Again, I'm not the judge, right? I'm not that smart. I don't know all the ins and outs of how this. You guys know way more about the criminal law than I do. I'm a civil rights focus, but I would love to look at Castro in the lens of Wilson. Physical obstruction and fighting words. Clearly, it wasn't fighting words, right? But physical obstruction, they said it requires willful physical obstruction.
It depends on how sensitive you are as to whether or not it's fighting words. I hate to say that, but
not, there's no way it's fighting words in Castro case.
No.
Right.
No, it should not be. But the point is, like they used to talk about victims in law school. You take your victim as you find them, right? The eggshell victim.
Yeah.
And it's the same way with officers. You got to take your officers as you find them, and you might have somebody at a death scene, accident investigation, high stakes, who, come on, just get out of our way, mind your own business, go away, treat you very gently. Somebody else at a traffic stop who makes you the primary focus, right? I mean, different officers react in
and suspects
different
act.
ways.
Yeah, everybody's human beings.
Yeah.
But we do want an objective standard. So at the end of the day, I would love to know the court. I can't wait to read the opinion. Whoever's going to, whether it goes to Levitt or it goes beyond to the 3, right? Because the Court of Appeals. I would love to look at this case and say, was this physical obstruction? Because the thing is, what I care about is I'm not the expert, behind the scenes. I'm not in the court like you folks. What I care about is trying to give my officers guidance about, hey, this was a good case or this is a bad case because of it complied with the Wilson's interpretation of obstruction.
Yeah, and that's got to be hard to train for. I mean,
it is very hard.
Officers, nobody's going to minimize the job that officers have, particularly when confronted by even somebody with good intentions. And you can debate that, I think, with DeCastro, right?
I definitely.
But part of its viewership.
Sure.
Likelihood.
He has more. Hey, I only have 12,000 subs on my YouTube channel, so he's doing better than me.
I don't even have a YouTube channel, so
right.
I just learned about doing the show.
Right. No, I think, and I will tell you this, since you brought it up. I know this officer. I've trained this officer who was in, the epicenter of this case. Really good officer, and I think we can agree that he has good faith. Like he wasn't, as far as he was just trying to do the right thing for his driver, for the violator. And now we're in court, and so far he won.
Well,
right.
At both scenes, one of the first things that the officers do to de-escalate, including the officer here, is that I don't care if you're filming.
Correct.
You film if you want it, which is, I will tell you, a sea change from when I was
huge.
When I was younger.
I would agree with that. I think we've come a long way because, again, what you were saying in that where they used to take the bait, the first thing they would put your phone down, turn that off, stop filming, and
correct.
now
Or hit him with wiretapping. In the East Coast, they would hit him with wiretapping violations.
Yeah.
Which is crazy. A felony.
Yeah, I mean that is just it is very different.
Yep.
There was a talk in the trial about the distance issue.
Yes.
And it's very interesting and very nebulous.
Yeah.
I believe because DeCastro says 10 feet's what I've seen in these other cases, and that may well be the case.
Sure.
And the officer says at the academy, we're trained if you're within 21 feet, very specific number.
Yeah.
You're not going to have time to react if somebody rushes you.
Yeah.
Essentially.
Yes. So yes, that's the 21-foot rule has been around for decades, and it comes from the study about people if a person can basically get a knife and attack you within 20 feet. In other words, if they're within 21 feet or less, you're not going to be able to. Your reaction is going to be delayed versus their action. All right. So the problem though is, and look, the officer is at least giving a reason why he's telling to get back. That's great. The problem is, I think we all can agree, there is no 21-foot rule with the First Amendment. There's no 10-foot. And in fact, it could be 2 feet in a nightclub where people are filming and a cop is arresting somebody 2 feet away. You can't necessarily tell the person get back 21 feet because there is no 21 feet.
Yeah.
What it is, it's totality of circumstances.
No.
At least the officer had a reason. He's not an attorney
We
like
haven't
us.
gone anywhere, just so you know.
But there is no 21-foot rule when it comes to the First Amendment.
So one of the things DeCastro does is he reaches for a second cell phone.
Mm-hmm.
And as I'm watching the video for that, I think, boy, he's lucky it's broad daylight and has a reasonable officer and everything else, because when you're in an officer's face,
That's a recipe for disaster.
and you start doing this with your hands,
I got you.
you are
Mm-hmm.
you're asking for problems, and nobody wants to be in that situation. Nobody's saying that officers are necessarily quick to react. Sometimes they are, obviously, but the point is, for somebody who's this constitutional law scholar that he claims to be, he seems to do a lot of things to create his own problems.
Well, he wants badges, money, and fame, and he's getting at least the fame.
And money's an interesting one. We haven't talked about that because there's a civil suit.
Not anymore. To
Did
my
it get
knowledge.
dismissed and get summary judgment?
I think so. Yeah.
But there had been at some
There
point.
had been, yeah. One of many that that's his. Maybe that's part of his income, right? Not just with this agency, but around the country. He has the track history around the country. This is his job.
Does anybody know how many 1983 claims he's filed? That'd be
Several,
interesting to find out.
But I am actually not aware of any successful ones. So his track record for being successful is, and I could be completely wrong, just with the hearsay. Yeah.
Okay.
Sure. I don't think he's been very successful.
So at the risk of alienating a few members of our audience, who watches? Who are the 500,000 subscribers to this Deletes Laws channel?
Me? I mean, I'm not a subscriber. I don't want to give him that kind of homage. But the thing is, like, I do watch cops perform because it's a very stressful thing. And in order for me to be a trainer, I have to know what these cops are facing. And I got to tell you, I've done pretty good with personal auditors in my job, but I've seen a lot of officers get baited with these guys because they know what buttons to push. When you're being told, there was one East Coast guy, he's really insulting about people's weights, about cops' weight, females, and so forth. Just a really atrocious stuff. I can tell you, I got to prepare these cops like, you're going to go out there, and when you put that badge on, you are the paid professional. You cannot let these people get to you. And it's hard, but that's just the way it is.
Is this a training opportunity for you to some extent?
Always a training opportunity. Absolutely. I think there's a lot of good things in this video, and there's some questions. I already told you my questions. I want to hear how Wilson pans out with this case. But I think the officer overall did really good. He didn't lose his cool. I love how he told him, you can still film. Just look, you got to back up a little bit more. Yeah. And I think he did a good job on the stand. Really good job on the stand, quite frankly.
I think that there is a whole sect of people who are watching because we get all of our information from the internet now and less than legitimate sources. So what frightens me about the 500,000 people who are watching this is that they're looking at this as some kind of legitimate source of information.
Right.
And that terrifies me.
I understand. Do we have any legitimate source of information anymore? I mean, that's
the last one,
right? No, but
right?
That's the existential question here.
The case law that I read that comes down from the Nevada Supreme Court that I cite to in my briefing, that's about it. Because even then, to the extent that I cite to it until it gets overturned.
So, if somebody wanted to do what DeCastro is doing or purports to be doing, how should they go about it?
Look, actually, I don't know if this helps, but my mantra here is act like a legitimate news source. In other words, how does the big three, how do they act when they come on scene and they want to view something that's interesting to them? Are they in driver's spaces, right? Are they saying, whatever? Right? They're not. They are from afar, not too far, but from afar. They're filming it. They are not antagonizing anybody. That's what I think is a true First Amendment auditor and how they should act. But I also tell the cops this: look at DeCastro, for example, as Fox 5 News. And I know it sounds kind of weird, but legally, and they have some similar authorities. And would you tell Fox 5 News to back up? Probably in this case, because Fox 5 News would have been pretty damn close, 10 feet or so, and talking to the driver.
There's an old joke about it. Obscenity is, I know when I see it.
I know when I see it, yeah.
I know when I see it.
Right.
And it's not that different with the press anymore with social media. I kind of know it when I see it, although I will tell you this one's kind of on the border for me.
Oh, it's definitely on the border.
I see people on Snapchat doing other things that I wouldn't necessarily call news, but this guy has so many followers. He's got, and he's got an agenda, right? A known agenda. I want
delete laws.
I don't like the police. I want to make sure that they're doing the right thing, whatever it might be. We can disagree with whether or not he knows that, but
well, as much as we have the position here, like be legitimate, act like one of the big three. Mine, from my kind of defense attorney perspective, is I don't care if you act a fool when you're doing the job, because again, there's nothing illegal about being anti-police. However, if you're going to take that position, if you're going to have that stand, if you're going to walk right up to that line, be prepared for the consequences. And I think what the issue is here with DeCastro, and again, it comes with some of his post-conviction behavior, is he completely was not prepared for the consequences. He acted like someone who could do whatever he wanted, however he wanted with it, and was not prepared to pay the price when he got convicted, right? And I'm specifically now speaking about his post-conviction behavior in the jailhouse calls and the crying in the courtroom and asking for leniency. Because you've had the conversations with your clients. If you are going to walk right up to the line, walk right up to it. If you're going to give your middle finger to the system, give your middle finger to the system, but give your middle finger to the system all the way. Be committed to that principle, or acknowledge that you have to change your views.
Well, I suspect there was a talk about him perhaps losing some viewers after this. Some of the subscriptions went down. And I suspect going into court crying probably didn't help him much, to be quite honest.
His macho image.
No.
Right.
Yeah.
But because the cultivated image, I mean, absolutely for this guy, I'm the guy that'll stand in their face, right? Geraldo did it 40 years ago.
Yeah. And then you're going to stand and what, cry? No. Because listen, again, I'm okay with the behavior. If the behavior had been consistent all the way through, but you turncoated, like the second you become a turncoat, like you have now lost any legitimacy that you might have had.
He's probably crying over the food in jail.
And the smell.
Well,
I mean, I can't blame him.
Well, one of the disappointments for me in watching the trial was he wanted to represent himself, and the court wouldn't let him. I think that would have been an interesting circus.
No,
I don't know that I disagree with Zimmerman for not letting him do that, because I always question the people that want to. I mean, I get that we're allowed to do that under our constitution.
Yeah, but you got a fool for a client.
Yeah.
No, I'm just thinking for the entertainment value.
There would have been a lot of views, but that's probably why I shouldn't let it happen.
Yeah. Well, with the sentence that she gave him, when a judge asked for, or a prosecutor asked for $500 fine, suspended sentence, she hands out 6 months, 3 months on each.
Yes, sir. Is this Mr. DeCastro?
It is in custody.
Okay, he is present, he's in custody. The attorneys can state their appearances.
You are Chris Courtroom on behalf of Mr. DeCastro.
Oh, is it happening?
No.
I think it might be happening.
If you want, you don't have to stand up throughout the whole hearing. It's up to you. Might be a minute.
All right, Alex, cut the music.
Mr. Orm, I'm assuming.
May I proceed, Your Honor?
Absolutely.
It seems that everybody agrees you have a right to film police officers. I'm not sure. I filed a lot of federal case laws suggesting you can film police officers, but the state doesn't seem to dispute that. In this case, you have a person who, for a living, this man for a living, that's his living. He films police officers. He has more than 500,000 subscribers. He is very, very famous as a First Amendment auditor. He's known as he testified around the United States and does this constantly. As I look at this case, there are multiple problems with it. It goes to trial, so let's start with what really happens.
It's got Chris Orm, huh? This is
I cite to it, and you have.
I'm sure Chris Orm did not come cheap for Mr. Chille.
The judge says, empty your pockets, suit pockets, all sorts of pockets, empty them. He says why, he complains it's a Fourth Amendment violation, you don't have a right to take my phone. And the judge also demands that defense counsel turn your phone off. And she said, I don't want to be part of your YouTube channel. And he said, we already are. This is the starting point to this trial. And the state says, well, the court has a right to, keep the court secure. Absolutely, you do. Absolutely. Have a right to determine who's filming. Absolutely. But what was interesting in the state's argument is they forgot to mention that the court never looked at the prosecutor and said, hey, turn your phone off. Make sure your phone's off. It's all directed at him and his attorney. You can't take cell phones. You can't do that. It's structural error to do that. And it also kind of shows that the court had an animus towards Mr. DeCastro. Then, Judge, he makes a statement to the marshal. It's unacceptable. It's unacceptable. It's clearly unacceptable. The judge was agitated by it. Understandably so. As I look at that, I'm like, I come in these courts all the time. You don't get to call a marshal what he gave. So, I understand. That's a different matter. He's not on trial for calling the marshal a name, which he shouldn't have called. Maybe you could hold contempt proceedings for that. There are remedies that a court like yourself can do if somebody's being disruptive. Just because somebody's disruptive in a murder calls your court staff a name, it's inappropriate. I would realize with a client, oh boy, this is not looking good. But that doesn't mean you're going to find or suggest that the person committed murder simply because he's acting or she's acting in a fashion in a courtroom that shouldn't have happened. But it was clear then that the trial was going the wrong way. So when we look at the facts of the case, that the police officer testifies that this auditor approaches, says that he's a member of the press, identifies him immediately as a member of the press. I have video here. I also have exhibits. And that he wouldn't back up. Now at trial, that was commented on by the officer a couple of times. He wouldn't back up. He wouldn't back up. The prosecutor argued it. Then they started on the 21-foot rule. It's an imaginary rule. We all know there's no such thing as a 21-foot rule. It doesn't exist. But nobody was stopping that. Not defense counsel was saying, where is this coming from? What rule are you coming to with this? And the prosecutors arguing, well, he's violating the 21-foot rule. There's no such thing as a 21-foot rule. And the state, to their credit, has abandoned and completely retreated from the 21-foot rule on this appeal. They don't argue.
Testify it was something you learned in the academy.
Yes. Yes, but I understand what it is, Judge, because I've used it myself in murder cases, and that is what they're argued that my clients are enduring is that if an assailant comes at an officer or a citizen, within 21 feet, you won't be able to draw your weapon. That's what they're taught. So it's something that we use in a self-defense case. Oh, look, the guy was, coming, and so my guy had no choice but to shoot. I understand that's what police officers are taught, but that's got no bearing on this. There is no 21-foot rule, and in fact, we just go to Click. Click is a First Circuit case, both the state and myself rely upon it. And in Click, I thought the language was so important to this case because in Click, they begin speaking about that officers, in that case, person's filming on the Boston Common, filming from 10 feet away, 10 feet away. That's very relevant because the police officer in that case said, Mr. DeCastro was 10 feet away. And so the First Circuit said that is 10 feet away. And then the First Circuit starts saying, police officers need to deal with provocative and challenging speech. They further identify that when a police officer comes in contact with somebody who's being rude or obnoxious, that they feel like they shouldn't be filmed, that they shouldn't have to endure that. And the First Circuit then goes on to talk about that officers sometimes retaliate because they don't like it. They don't like it. And they said that's what happened in Click. The officers didn't like it. You don't film us. You have no right to film us. Okay? And so when I look at the situation, I'm like, officers, we have a right to film officers. In fact, we have an actual statute on it. NRS 171.1233. This is cited in page 2 of my reply brief in footnote 1. Subsection 2, subsection A states, a peace officer shall not act to interfere with a person's reporting of law enforcement activity, including, without limitation, by A, intentionally preventing or attempting to prevent the person from recording the law enforcement activity. You have a right to do it. We know it by statute. We know it by federal law. So what does Mr. DeCastro do? When the officer tells him back up, I can prove he does. I've attached the exhibits. I don't, if the state wants me to, I'll put it up and I'll show it, but we can see from Exhibit A that where Mr. DeCastro is standing, he's standing in a particular parking space. We can see in Exhibit B, he has now moved back into the back parking space. I don't, when I say back parking space, I know that may be not a good record, but he's moving away.
Right, it looks like it's in a parking lot.
Yes, it's a parking lot. He's moving from one parking space away. You can see it's away from the officer. So the state, to continuously argue he would not back up, why are they doing that? Because they want to say he won't follow commands. And the accurate answer was, and I think the court would say, if you were asked to look at this case and say, what did Mr. DeCastro do when he was told to back up? He backed up a short distance. That would be fair. Maybe the court would not like that language, say maybe it's a few feet. But he did back up. What is not fair is he would not back up. He would not comply. He did not back up. And then the officer was asked, did you tell him how far? No, because he was disrupted. So I couldn't tell him how far. The 21-foot rule. There is no 21-foot rule. Click said 10 feet was fine. And in Click, what's more interesting about it is the officers, what Click is deciding is not like this court deciding whether there's criminal activity. Click is suing the officers. And the officers are over in federal court saying, oh no, give us qualified immunity. And the federal court said, no, not for this. You're not getting, for arresting somebody who's filming, you're going to get sued. You're not getting qualified immunity. You're going to have to fight this and go to a jury. I think that's very relevant because that's what's going to happen with this officer. Undoubtedly, you know he's going to sue, and I think he's already started that process. I'm not a civil lawyer, so don't do that. But I know that that is what's taking place. So what is hindering this man from obstructing him from writing his ticket? He can just simply write the ticket. He can look at Mr. DeCastro and think to myself, here's one of these auditors, walk over and write a ticket. He was asked the question, which I thought was really good at trial. He was asked, how did he obstruct you? How were you obstructed? And he said, well, I didn't know what his intentions were. I didn't know. Maybe he was armed. Well, that doesn't obstruct you. How does that obstruct you? That doesn't, he never gets in the way. So let's fast forward to Wilson. Okay? 3 weeks before this trial, the Court of Appeals considers one of my arguments here that the statute is unconstitutional, vague, and ambiguous. The Wilson court determines that the only way to impede, the only way that you impede is that you have fighting words or you physically do it. And the exact language of it is, we interpret 197.190 as applying only to physical conduct and fighting words. The court further explained that blocking the path of an officer may amount to obstruction. Well, that didn't happen. You can look at the video. There's no blocking. There's no blocking that goes on. And they also say that it could be non-aggressive, which made me curious. So I went and read the case. I thought, what could non-aggressive be? And it makes perfect sense. I would have never seen how non-aggressive could be obstruction. But what they then cite is they were pulling over an individual, police were. And the guy who I guess is armed then starts to run from police. Well, now they've got to go chase him. So clearly you're hindering the police. So that made perfect sense, and that's the case they cited. What is interesting about Wilson is they also go on to say, as construed by this court, NRS 197.190 prohibits only physical conduct and fighting words that hinder, delay, or obstruct a public officer in the discharge of official duties or powers. As such, law enforcement has no discretion to arrest persons for protected speech or for physical conduct that is merely annoying and offensive. Judge, I have no doubt, if you watch, I know you've watched this video, and I could see how anybody could look at this and hear the speech, get in your car, little doggy, and write your ticket, and find that to be annoying. I see that. But that's protected, and we've been told that's protected now by our courts in Nevada, by numerous federal courts. They went on to say the district court did not, so in Wilson was convicted, appealed, just like I'm doing here. And they point out in Wilson that on appeal, this court explained the district court did not have the benefit of our interpretation of 197.190 as being limited to physical conduct or fighting words, and therefore did not consider whether there was sufficient evidence that Wilson engaged in physical conduct or uttered fighting words so as to support her conviction, and the case was remanded. Why I think that's important is because one of sort of the big picture that I want the court to see that I'm arguing, I think Judge Zimmerman was put in an absolutely terrible situation. Here's look at all this litigation we're doing here. This isn't new. I didn't come up with, oh, look, there's a new case that came out about a First Amendment issue. A lot of the cases I'm citing are, 20 years old, 15 years old. This is known law. If we have this issue before you on a case, isn't it incumbent upon me to file this pretrial?
I wonder why that didn't occur in this case.
And the state says something interesting, which I understand the state's advocating. The state says that trial counsel filed a memorandum. Well, I'm like, it was comical. I understand what the state's doing. They're saying they need to try to protect their conviction. But the trial counsel, what he did is he filed some memo that right when the judge is making her decision, finding him guilty, she's like, what memo? And I filed them. She didn't read it. And then the state correctly, the state said, strike it. It's late. So what trial counsel does is, at the last minute, can you imagine I'm coming in here talking about the facts and all of a sudden I'm like, oh, Judge, there's a First Amendment issue. Like, well, don't you think you should have briefed that and let me know? And I hear the state's argument, and the state says courts are presumed to know law. And I know you know law, but I also know, Judge, that we get into issues. You've been on the bench a long time, so I know you know the law. But when, let's say we're going to talk about a Miranda or Messiah issue, I think that it's incumbent upon us to give the material to the court, let the state oppose it, let us reply so the court can look at everything, have the court's clerk go maybe find research that interests you on this so that you can make an informed decision, as opposed to at the very last minute in a factual trial, like, oh, by the way, there was a Messiah issue. I don't understand why he did that. This was the issue. This should have happened beforehand. This should have been litigated beforehand. The court, like yourself, just like we're doing here, we should give you the opportunity to go look at it, and maybe my rendition of it is not the way you want to go. It's the state's rendition. But the fact of the matter is, at least you had it, and Judge Zimmerman didn't. And that's ineffective because he should have showed the court these issues. And if he had, just like here, the Wilson case would have come up. I know it was brand new. It was only 3 weeks before the trial. But then the court could say to the state, hey, you've got to have physical conduct or fighting words. We can't just do this on driver's safety. Because at one point, the judge ruled, because the prosecutor kept arguing, and the police officer testified, well, the driver had a right to privacy. Like, the driver doesn't have.
Drivers out in public. I don't know if the driver had a right to privacy. When you're out in public,
you don't have a right to it. And here's another thing, Judge. The state then comes back in their response. Mr. Chen always does an excellent job, and he did here as well. And he cites a bunch of cases, every single case. It made me realize when I read it that they have real legal problems. They've got problems with the law. Because what I did is I read every single one of their cases, and what I found was, oh, this is not at all what these things stand for. In other words, in fairness, they were saying their time, place, manner restrictions. Yes, true, the cases did stand for that. But let's start with Philadelphia, Fields versus City of Philadelphia. Now, when I first saw the video, what came to mind, just jumped to my mind, was I looked at it and thought, hey, wait a second. Didn't those people in George Floyd, weren't they filming it with cell phone? Now, I hadn't really followed it that much, but I kind of thought about it and it ran through my mind. So I then started pulling up the exhibits that I put, and I looked at it and I said, well, boy, those people are closer. They're closer than Mr. DeCastro. Another thing that came to mind is, although I didn't really follow that trial very much, I did remember the firefighter. She's an off-duty firefighter, and she came to court with her uniform on. It was devastating for those officers because she said, I tried to tell them, and then they started saying, if you were a real firefighter, you'd know not to get involved. And she said she started using profanity at the officers. And she, at one point, is within a foot of the officers. There's an Asian officer in the back of the vehicle. She comes very close to him. When I look at that, I'm like, well, how is she not in the same situation as him? She's admitting she's using foul language. And I remember her trial testimony where she was crying, and I think it was extraordinarily impactful. I want to talk about something for a second, Judge. Police have to deal with difficult people. I know that because I witnessed it in your courtroom. Right there, right back there, right by the door. And I seem to remember I was in a capital trial, came up from a break, about 1 in the afternoon. And what I see is Officer Hawks having to deal with, I don't know if she's a homeless lady or what, sort of small Caucasian lady, but out of control. And I'm watching, almost nobody's in here. And she's saying horrendous things to Officer Hawks. There comes back up because I know there was a female officer, and they're trying to talk to her. Your marshal showed incredible restraint. I know that because I watched her try to kick him in the groin. She tried to kick him, and I watched it happen. And I don't think she was arrested. At some point, they did everything they could to just get her out of here. She was so obnoxious and abusive to your marshal, yet the restraint shown was remarkable. I remember that because I addressed it with Officer Hawks. How did you do that? To me, it was amazing that a human being could practice that type of restraint, and that's what he did. And that's what this officer should have done. He was angry. When the state says to you, and when the officer said, I was concerned for officer safety. No, he wasn't. At the point when he says to him that annoying language that we call, and the federal courts have said it, provocative and challenging, get in your car, little doggy, and write a ticket. First of all, he's telling him to write the ticket. He's not instructing him. He's just, it's like a directive. Counsel, be quiet and sit down. Okay, that's a directive. But you're not instructing me from being quiet and sitting down. He's telling him to do it. And so I don't understand how the state can argue when I can see it for myself that the officer was concerned for officer safety. When he says that, when Mr. DeCastro says it, you can see the officer just gets irritated beyond my God, you don't say that to me. He just comes at him. He doesn't pull a taser or anything like that. He's like, you're detained. And then he grabs him pretty hard. And he's trying to say, well, I'm a member of the press. I'm a member of the press. You can't do this to me. He tells him, call your supervisor. Don't do this to me. And he's like, he brings out 2 cell phones, so he's not armed, and you know what he is. And even the officer said he knew about First Amendment auditors, but didn't say that they shoot people, because he was asked that. He goes, I don't know if I said that. He was agitated. This wasn't about fear. This was about, truth be told, you can see it's obvious. This officer was agitated. And the federal courts talk about that. They talk about a lot of these officers don't want to be filmed. And I want to go back to City versus Philadelphia, or Fields versus City of Philadelphia, because in the state's answering brief, they question, hey, why would you be bringing up Floyd? Are you bringing that up? And I realized the state saw, why are you bringing it up? I saw it was directly relevant to filming police. So since they cited Fields versus City of Philadelphia, I went and read it. And it starts off, so what that is that's an individual who's got concerns about unions, and they're filming in Philadelphia. And the court starts off with very, very, very interesting language. The courts, this is the Third Circuit. The Third Circuit begins their analysis
Where's Kim to spill some water?
In 1991, George Holliday recorded video of Los Angeles Police Department officers beating Rodney King. They continue to go on about that. I cite that on page 4 of my reply. This case involves retaliation. Individuals making recordings have also faced retaliation by officers, such as arrests on false criminal charges and even violence. And that's because they're recognizing this. The federal courts around the United States are recognizing that police sometimes don't show the restraint that Officer Hawks does. If you're being filmed and you got some irritating person, sometimes when we walk out of these courts, we got press that are like, what just happened? Did your client just get convicted? It's like, yes. Did your client just, they want to sentence him to death? Yes. And you have to be calm. I can't just grab people and do it. You got to suffer it. Suffer it. He didn't stop anything. He didn't grab the officer. He backed off from the officer. Yes, maybe annoying. Yes, maybe provocative. But it is not obstruction. It's not resisting. These are trumped up charges. And that's what the cases show. They can't show you a case. Not a single case could they rely on to show this is obstruction or resistance. Not once. And in fact, like I said, I think trial counsel should have presented it to the judge beforehand. Then the judge could make a correct decision without even a trial. I think if the court had seen it beforehand and not being so agitated by calling the marshal a name, that the court could have ruled that this is clearly protected First Amendment speech. Judge, also, so I believe that I've argued that this is a First Amendment violation to convict him of it. It's also under the Wilson decision in the case, federal case law we decided it is clearly arbitrary and capricious. It's being applied incorrectly, and the court did not have the benefit of the Wilson decision because Wilson remanded it to tell the district court you need to look at this. That did not happen here, and so that's a problem. I argued judicial bias. The state claimed that there was no objection. Again, trial counsel didn't object when phones started being taken, didn't make any kind of formal objection. But in Echeverria and in Gurry was my case, it's murder of an FBI agent, there was no objection. It was well before my time, but I do it on post-conviction. I handle it on post-conviction. And it was that the trial judge had been, the FBI agent who'd been murdered, had actually investigated the trial judge. And so they found that that was an implicit bias, and so therefore there was reversal. The judge should have recused herself. She should have realized maybe I should hold this man in contempt proceeding, and send this to somebody else. She didn't do that. But I also think it was incumbent upon defense counsel to do a better job and inform her of that. And that leads into my last argument of ineffective assistance of counsel. And I know that on appeal it's rarely considered. However, I cited case law that it's clear as day, and I think the court can already see why wasn't this brief? Why is this whole hearing not happening prior to the trial date, so that Mr. Chan or whoever, it was Miss Agnes Alexis, why did she argue this against trial counsel and let the court make a decision? Judge, under the circumstances, reversal is mandated. It just, in every different area, I think under the Wilson decision, I think under the Click decision, I think on every single decision. And so I just want to make sure, Judge, that I cover all my points before I turn it over. And that is, they say Mr. DeCastro was angry and hostile. No, this is what he does for a living. That's how he approaches them to see, can they handle it? I think in other videos, if the officer handles it well, like Officer Hawks, then he kind of calms down a bit. He did.
I'll object to that as facts that are not in evidence, speculation.
I'll withdraw that argument. And what other time, place, manner restriction? When to do this as an auditor, to do this?
Target parking lot, right?
Yeah, in daylight, broad daylight. When if it was a female officer, not that if it's a female officer on a lonely highway going up to Ely, and all of a sudden somebody's approaching at 3 a.m, I think that's a different story. That shows officers like, God, what's happening here? And it's fearful. He does it in the most common way. He comes up, hi, I'm a member of the press, annoying, provocative, all of those things. He's protected. It is one of the most, it is something that is sacred to what our system of justice is. And one of the decisions I cited said, this is the difference between a free society where we can go up and be obnoxious to police. Hey, I see what you're doing. I remember from the time I was in law school, I cite the case, but I don't wonder if you remember, Mr. Chen remembers it, where somebody comes up to an officer and calls up, which I think is really, I remember as a law student, you shouldn't do that, that's bad, right? But the reality is I then learned from the Supreme Court, it may be bad, it may be obnoxious. If it's your child, you'd be like, what did you say? But it's protected, Judge, and he didn't do anything to violate or have those protections taken from him. I'd ask that you do that.
Thank you, Your Honor. First, I'd like to thank Mr. Oram. Considering that our response was called comical, I appreciate the nice words from him today. Regarding first and foremost with the ineffective assistance of counsel claim, even if counsel could have done it, we're still focusing on the prejudice problem. Ultimately, we're here, and this is the appellate court for this matter, so this court's going to make a matter of law decision. So I think ultimately everything regarding that issue gets resolved on a prejudice problem, whether or not Judge Zimmerman was surprised at the information that he wishes to put forth today. Now, with regard specifically to the First Amendment claim, Mr. Oram mentions that we cite to a number of cases, and the cases factually don't support our position, and I think we recognize that in our brief. There are cases where police officers have stopped individuals from filming encounters that they absolutely had a lawful right to do. This is why the court consistently talks about time, place, and manner restrictions. We don't doubt that that's the case, but to suggest that we didn't read those cases, I think is an unfair characterization, because what we're trying to focus on is whether the time, place, and manner restrictions were present in this case. Now, what I would argue, and what I think we argued in our brief, is cases like Lynn are relevant to the extent that in that case, the individual clearly was not impeding, obstructing, or being a problem to police officers. The only thing that individual in Glick was doing was filming officers, and the officers were upset by it. That's a very different situation when we're talking about time, place, and manner in this case. Yes, it's in a public parking lot, but you have to realize that as the facts came out, that the officer was letting the individual film until he approached the driver. Now, I agree, privacy is not a thing necessarily in public, which is why we didn't argue it. However, there are other concerns for time, place, and manner regarding safety of everybody involved, including the fact that when the officer is writing a ticket, when the officer is communicating with this lady who's been pulled over, when that lady is sitting in her car and not free to move because she's subject of a traffic stop, that the scene needs to be secure. Now, I appreciate that the individual, Mr. Castro, could have plenty of followers, and he might have followers. I didn't know him before this date, and it doesn't appear that the officer did either. So ultimately, the officer is treating this individual as someone who's filming, but doesn't know what the ultimate motivations are. It could be to film, it could be to do something else, it could be to interfere with the driver, and I think that's what the evidence shows in this particular case. Not only did he approach the driver, the key part where the obstruction begins to occur is when the officer asks him to back away from the driver. He says, well, I'm a filmer. Great, you can film, but I need you to back up. And again, we're quibbling over how much the backup was, but I think
Clearly backed up.
he backed up a couple of feet. There's no question about that. But I think what the officer testified to was he wanted it a further distance based upon, in large part, how Mr. DeCastro was operating. Now, if Mr. DeCastro had backed up a number of feet and continued recording and wasn't saying and doing the things that he was doing, I think we'd have a very different situation. But the problem is,
Mr. DeCastro's supposed to know that he has to back up further.
the officer instructed him in the video that to continue backing up, and rather than backing up further, he stood his ground and said, no, I'm relying upon a fictional 10 feet rule, which I don't think is a matter of law. I don't think the First Amendment says 10 feet is automatically permissible, because you can do a lot of things.
There are courts that have held 10 feet is sufficient.
Depending on what the situation is, all right?
I agree.
If I pull out a gun, is 10 feet still sufficient? We're an open carry state, for instance, so there are individuals who can carry guns. So if we were to say automatically that I'm 10 feet away, and that as a matter of law, that's sufficient, I think it's very different if the individual is doing certain things. If the individual has a grenade in their hand, that's why it's time, place, and manner specific. We're not advocating, I didn't advocate for a 21-foot rule, even though that's what the officer said he was trained to do, in that he wanted the individual to move back a certain amount.
But he never vocalized that.
He
He
didn't.
never verbalized, said, hey, I want you to move 20, 21 feet back, go back to this line, don't come across this line. There was none of that, because it happened so fast. I mean, the officer testified it was within like 10 to 15 seconds.
Yeah, it's all on the video as well, Your Honor, so I agree that he doesn't give a specific number. And even if he had given a specific number, it's not that that specific number is somehow constitutionally permissible or not. But the point is the manner in which this individual, who's unknown to the officer, is interacting with that officer in that very manner is what the issue is for us. And based upon that, the officer can't continue to feel that he can do his job, the traffic stop, speaking with the individual, of doing any records checks that need to be done, of writing the actual ticket, while this individual is yelling, refusing to move back at a further distance, and again, with unknown motivations. In hindsight, we can look at him and perhaps say, well, he was only here to put this on his YouTube channel. But ultimately, at the time that it's happening, this officer who interacts with him, who even tells him, you're allowed to film, but I need you to continue backing up, I think that's what the reasonableness is. That's what the time, place, and manner restriction is, not some magical number. as we point out in our brief, I think what Mr. DeCastro believes and what counsel believes is that because Blake said 10 feet, that there's this line of 10 feet, and no matter what, I can do whatever I want within 10 feet. And I think even Wilson, although I understand it's remanded for further hearings, goes against that proposition that, oh, there's some type of magical number or anything like that. This individual in Wilson is yelling as there's a suicidal individual who obviously a delicate situation. The police don't want this individual to hurt himself, and Wilson continues to yell and interfere with what's going on. Specifically in Wilson too, that even though they say physical conduct again is made up of multiple different things, including what we do with our bodies, but as well as what we're saying and how we're acting throughout the course of the interaction. And Wilson acknowledges that. In fact, they cite a treatise, what constitutes obstructing or resisting an officer. And if you look at that particular treatise, I mean, it goes on for multiple pages of various conduct that would entail obstructing. So here, it's not simply about the words. It's not simply about the fact that Mr. DeCastro was annoying. It's not simply about the fact that Mr. Castro was saying things like calling the officer doggy and whatnot. It's not about that. It's the totality of the circumstance which prohibited the officer from being able to safely and adequately conduct the traffic stop. And that's.
Well, he immediately released her.
He did.
Also, I mean, he gets out of the car. I mean, it appears to me he was going to release her regardless because it was so fast. He said, "You're free to go," and then he went to take care of the other issue.
Yeah, well, I mean, what we have in this particular one is he went and did the records check, and then he mentioned too she was surprised or even confused by the fact that she had an issue with her registration. Exactly. Now, again, I don't want to. It's speculating to assume what happened there, but certainly those are the facts that came out at trial, and so ultimately, whether he was going to ticket her or not, he may have ticketed her. Obviously, he pulled her over because the system, as he testified, said that there was an issue with her license. But because of the fact that this all went on, perhaps the obstructing was that he didn't feel comfortable to write. It wasn't worth writing this ticket. She already was informed of it so that he could deal with this other situation of this individual who was clearly obstructing with his ability to get to the very end of his investigation, whether he was going to release her or whether he was going to write the ticket. But the problem is the impediment is the individual who's continuing to yell and stand a number of
You
feet
could
away.
never do that then if all the officer had to do was say, because I had to go deal with this, I couldn't write the citation, right?
I think it's time, place, and manner specific though. In this particular case, when you watch the video, I think he is that much of a problem that this officer ended up, talking to him more.
So, but what's the obstruction? It's not the words and it's not the filming. I mean, the officer, to his credit, he said right away, you can film, you just need to back up, and I understand he didn't want him talking to the driver, but it didn't appear to me as though after he was instructed, don't talk to my driver, he didn't talk to her anymore. Is that accurate?
That is accurate, yes.
Right.
And
It's-
I don't want to testify to that.
Right, and then he backed up. I mean, I understand the officer didn't think it was enough, and so, I mean, is it just that he didn't back up far enough for the officer? That was the obstruction?
He didn't back up far enough in addition to the manner in which he was acting. So had there been a conversation saying, officer, and again, everything is so fact specific, right? But the fact that DeCastro is immediately yelling, arguing with the officer about the amount of backing up that needs to be done, that's what the issue is. It isn't about the space in itself or the distance in itself. It's a combination of factors of everything involved. Now, Mr. Oram says that depending on who the officer was and where it was at night, I believe where it was could play into it, but I think it's an unfair statement to assume that some officer, simply by virtue of being a female, would somehow be in an incredibly worse position, and that Mr. DeCastro, for instance, could treat her differently or would need to treat her differently than the officer that we have involved here. I think
Well, if it was in Ely on the side of the road at 3 a.m. on that road between the
for any
Reno
individual,
and Vegas,
for any individual, I would agree. For any
I
individual.
agree.
I'm just saying that it seems incredibly sexist to say that somehow a female officer would be unable to defend herself on that Ely road, but somehow a male officer would be automatically good to deal with the DeCastros of the world who want to interfere with the investigation. That's what I'm simply saying. That I at least wholeheartedly disagree with the characterization there in terms of the time, place, and manner. But I agree, an isolated road could be a factor, but they're all just factors. Now, this case has its own facts. There will be other cases that come through the line, but I'm just arguing that pursuant to these particular facts, he was convicted of obstructing. And Mr. Arm doesn't address at all that second issue, which has to do with the resisting portion of things. Now, I think the case law is
that
clear.
Lisenby case. I mean, so even if, let's say, even if I agree that there, this was an obstruction, it was unlawful to detain him, that Lisenby case seems to indicate he still can't resist.
And that would be our argument. He hasn't addressed it, I'm sure he will on his reply, but that's the last of my argument. Thank you.
And I'll address that. First of all, I didn't mean in any way, Judge, you could take the biggest male officer. I meant just giving the scenario. It could be 1 in the morning, 3 in the morning, female, male. I didn't mean it that way. I just meant the visual of how it's different there. What I just heard was sort of interesting. Mr. Chen just said, I didn't argue the 21-foot rule because it didn't, it's not applicable. They sure did drop, didn't they? That's what they argued. Even the prosecutor argued it. So Mr. Chen is only retreating from it because it's not a rule and it makes no sense. It's something used, as we talked about, in self-defense type issues.
Right, but if the officer would have said that, I'm not sure that would have been unreasonable.
I
really want you to be about 21
Yes.
feet back,
Yes.
give me some space, and
Right.
don't go past this white line. I mean, there were markers in the parking lot.
Right. And if he had grabbed his citation started and Mr. Castro got in the way, you're not going to do that. It's obstruction. This is an obstruction. And the 10 feet, I agree, is it 10 if you're only 9.5 feet? No, I don't think that's the point. The point they're trying to make is that our statute tells us we can film police officers. It doesn't say 10 feet, 21 feet, it just says filming them. When he was told to back up, he did. And the state is now saying, yes, we all agree with that. We're quibbling over words. I'm only quibbling over words because they kept saying at trial he wouldn't back up, which is not quibbling with words, it's inaccurate.
That's true. I mean, the officer did testify on direct examination repeatedly that he didn't back up.
Yes.
But on cross indicated, well, he did back up, he just didn't back up.
Substantial.
Yeah, he may have backed up inches, he didn't substantially back up.
Now, with regard to what are the intentions, I keep hearing, what are these intentions? He didn't know what the intentions are. And then that's why I put up, because I think there was testimony that I don't know who this guy is connected to. You don't know who this person is. Well, the officers in Floyd didn't know who these people were. The people filming, they didn't know it was an off-duty firefighter. They probably had done something different if they knew who they were dealing with. But they didn't know, and so the same arguments could be made. Oh, they're within 10 feet, officer safety. Maybe those are all gang members, and they're the same gang as George Floyd. It's his brother, I won't be sexist. It's his sister who's gonna pull out a gun, or some other person, male, female, gonna pull out a gun and shoot it. So we are doing this for officer safety. No, it isn't. And the courts, you can look at George Floyd and realize the courts in a big case in the United States said, these people have a right to do that. And the question I really ask, I think is important. There was no abuse. The officer wasn't doing anything abusive to the driver. It's clear as day. Okay? But if he was, and he caught him on film, and now it's hitting CNN and Fox and all of this stuff, then they say, oh yeah, we caught him, and 10 years from now, the Third Circuit's going to be quoting what he did. But he didn't catch them. So is that the standard? Can we film police officers? But if they're not doing anything wrong, and I'm using obnoxious language, then I can be arrested? Is that what the standard? It isn't, Judge. The application.
You're allowed to be annoying.
I'm sorry?
You're allowed to be annoying.
You're allowed to be annoying. You're allowed to say,
You're allowed to be obnoxious.
Yeah. And I realize we as lawyers appear in front of judges all the time. We appear in front of juries. We're trying not to, want to be obnoxious. It won't help your case. It won't help that. But I recognize this is some cornerstone. It's a foundation of our nation. The resisting. Did you notice the officer said, "Oh, when this resisting is happening, my body cam all of a sudden doesn't go out." He testified he never resisted, and you can see it on him. He tells him, "Don't do it." The officer really grabs him hard, and then he's like, "Okay, I'm walking." You even see him with his camera. "I'm walking back to your car." There's no resisting. He's trying to tell him, "You're being unconstitutional." He does say, "You can't do this to me. Call your supervisor." But they get him in handcuffs, and there he sits. By the way, the state didn't ask for him to sit there. Agnes Lexus asked for a suspended sentence, and Judge Zimmerman decided to give him the maximum. He's been in there 4.5 months for this. And I kind of wonder.
To that characterization, it's not a maximum.
It wasn't a maximum, no.
Oh, you're right. Okay, you're right. I stand corrected. For whatever reason, I guess misdemeanor 6 months, 6 months. Yeah. So she gives him, but the state didn't ask for that. They asked for concurrent 90 days suspended. It goes to show what really happened. There were so many different errors, and I can tell the court has a good handle of this. Judge, there is no resisting. It was an unconstitutional arrest. The man should receive the benefit. I mean, we have a beyond reasonable doubt standard. We can look at Wilson. I now hear the state really struggling. They almost sound like me in a bad murder case where they're saying, "Well, what is physical conduct or contact?" Because that's what Wilson said. And they're struggling with it because they don't even, because there's no physical contact. Backing up and filming and then pulling out a second camera, it's not physical conduct. There's nothing physical. He doesn't do anything physical. The officer just lost control. And he was irritated. Maybe we understand. It's not.
Yeah, you can understand. I can understand.
Okay,
And
yeah.
it kind of comes out of nowhere.
It's out of nowhere. It's, who wants to be called names? But that's what the courts are all saying. You've got to endure this. Our citizens have a right to do this. And it also keeps our police, these auditors do help in some way because sometimes they prove police are doing, if it was an auditor on what he did, and that one was like, "Oh, he was saying these things to me." No, he wasn't. If I'm not a witness to it, no, he isn't. And the video shows that if somebody was filming it, he wasn't doing anything wrong. So some false allegation by some crazy lady, okay, it helps them sometimes. And also sometimes it catches bad police officers. Here, what we have is a situation where you have a right to do it. And so for those reasons, I ask that you grant the appeal and reverse this man's conviction.
Anything else from the state?
I would only briefly say that in the Floyd case, no one was arrested. That's what the distinction is there. So people were allowed to film the encounter, and obviously other things happened from that case. The issue is not that they were filming, that no one was arrested there. And the case law makes it clear in Lisenby and other ones, if there's a probability of substantial harm or death, then individuals can actually interfere and wouldn't be obstructing. So the case law, I just want to point out that distinction, but otherwise I have nothing else.
Okay, so this time the court's going to grant the appeal and reverse the convictions based on its First Amendment protected conduct. And Mr. Orm, you can prepare the court.
Yes, ma'am. Thank you very much, Joe.
Whoa.
I did not expect that.
Nor did I.
Thank you.
Holy crap. Wow. That's just what we need. An emboldened Chille.
No. That is an arrestable offense.
Yeah. Oh, yeah. Randy. Chad Levitz Marshall. Well, he hated Kim Blandino for sure. Oh, my goodness.
He almost got arrested again. Wow. Well, yeah.
Hey, where'd I go?
All right. There we go. Wow, I did not expect that.
Nor did I. Oh my goodness.
I mean, you can tell by her questions right away that that's where she was headed.
I saw in the chat people like, oh my gosh. But sometimes you don't want to read too much into that. Sometimes they want to rule in favor,
Yeah,
of,
they
for
want to air
example, for the prosecutor and get
they
them to
want to air
develop
the
their
argument they're
argument
ruling
more.
against.
Yeah.
But
Wow.
she bought the whole Chille line.
Yeah. I mean,
I did not see that coming. Yeah, yeah. I mean, I think he obstructed. I think it was a bad decision from Judge Levitt, who I generally like. Where you were in front of Levitt with all of that.
Yeah, with Kim Blandino.
With Blandino.
I mean, and yeah, I'm a little surprised, really, by the.
We were going back and
decision.
forth too. You tried a case with Chen, the prosecutor, like 10
Yes,
years ago.
yes, 10 years ago, the Carlos Barone reality TV shooting case.
Oh my God,
that was.
I'm surprised. I really think that's a bad decision. I think it should have been affirmed.
Yeah, I mean the full time, place, and manner.
Oh, here we go. Chille's gonna be off to the races now.
Oh my gosh! And now all the lawsuits. Holy cow! He's gonna. Who's he not gonna sue?
That
is incredible. I can't believe it. So I mean, she was. Yeah, this is what constitutionally protected First Amendment. I mean, I get that. But I think what Alex was saying with Mr. Chen there was that this is.
It wasn't the filming though, but she bought it. He conflated the filming with the obstruction, and the judge bought it. I think she's just wrong as a matter of law.
Yeah, I mean, that's that's crazy because I mean, look, I mean, he's talking to the person that's being pulled over, telling him, hey, shut up, or don't say anything, or whatever. He's, giving all the advice he's giving. The cop tells him to back up. The cop can't be fighting two fronts. And if he doesn't back up enough,
it's crazy.
I don't know. That's why because it's
absolutely insane. So
that's why, because
you're a scene.
I would be more sympathetic to Chille if, the cop was said back up and said, okay, backed up, just shut his mouth and kept filming. But because he was,
yeah, he was telling her not to cooperate and all sorts of stuff. Okay, so
Yeah.
right here we have a question. A district court judge, that is the procedure. When you file an appeal, that's where it went to. This is standard Nevada procedure.
Yes. Yeah, you need Kim Blandino. Kim Blandino knows more about appeals than I do. That's for sure. Honestly, I said that he does get a kick out of that. But
all right, well,
he loses more cases than I do, so that's why he knows more about appeals.
On the downside, the state of Nevada has and the United States has slid further into chaos. On the upside, we're gonna have more Chille material because now he's gonna be emboldened and just do dumber things.
Oh yeah, he will be more. More brazen. I mean, why wouldn't he be now?
Absolutely.
There's no, not like there was any humility beforehand. Now there's even less. Oh my goodness.
That is a wild one. That is not what I expected. I mean, I always thought it was kind of close. You and I had this conversation before it even happened.
Right.
I'm like, yeah, it's a kind of hard thing to prove. But then when I watched it, I'm like, no, he was obstructing.
Right. I mean, that's the thing is, I mean, I'm obviously as a defense attorney, I am a little sympathetic to these, people that film the cops and the cops that don't want to, and it's not that the cop didn't want to be filmed, but I mean, I do like these, as much video as we can because it does cut out a lot of BS for both sides. I can go to my client and say, look, you're on camera doing X, Y, and Z. So you might not want to.
Oh, the body cams,
or
and the other way.
Yeah, or the body cams come out and they're really good for us because hey, it's like, look, he did everything he was supposed to do. And because I had a guy like here, because Nevada is a stop and you have to identify yourself by law. If you're stopped by the cops, the minimum you have to do is identify yourself. And so my guy did that. He told him his name, and because they got him for that. And so I actually did win that that case because he did, and it was all on because of the body cam and the video that we had where he said, hey, my name is John Doe, and so we, he complied with the law when they're saying he didn't. But that's why I love the videos. Really, it just cuts out a lot of nonsense. But I'm really shocked by this decision.
I did not see that coming. I thought it was good conviction, but yeah, I'm used to the process. That's why we have a process, and there's an appeal, and that's one of the problems is you only have the defendant only needs to win once.
Right. And I did think Judge Zimmerman's sentence I did feel was a little bit harsh, especially because I don't know that he had any prior criminal history. I don't know what his deal is, but it's a non-violent offense, and the 6 months or whatever she gave him, was pretty, especially the prosecutors asking for what was it, 30 days suspended and a $500 fine, and but this reversal is crazy in my opinion. It's just unexpected. I get her reasoning as to why this is sort of protected First Amendment activity, but wow.
Yeah,
I guess he's going to get out tonight.
I think it shows a severe misunderstanding of the First Amendment. That's not what's going on. We open with, yes, you can film.
Right.
So that's really not where we're at with the first. That's we really don't have it. The filming was not in dispute from the get on this case. It's the yelling at it. It's the not allowing him to secure the scene of a traffic stop and then resisting.
Right.
And that's where you are. But all right. On to fun stuff. We have restarted the channel.
Yes.
Viva Las Vegas.
Viva Las Vegas 2.0.
I've been all over you, but you actually do. You have it's like an intro video or something like a.
Yeah, it's just the intro video for those that haven't subscribed.
Hey, I'm back.
And there will be more stuff coming soon.
Everybody go over there. Hit subscribe. We need to get them back up so that we can do a live stream over there.
Yes, that's what we need.
In fact, thank you all so much. I just posted something in the community tab yesterday.
Yeah, no, thank you for so many that already have subscribed. So
yeah, we got a good response on that. When are you gonna drop your little intro video here?
No, it's on there.
It's on there. You just did it.
It's on there. It's been there.
For how it's been there for when I checked
since before we started. Since before we started that's probably because you're a subscriber. I think it's one of those like for. You know how it works.
No, I don't know how it works. I don't know.
Well, no. You just print money now, so you forget how it works for the rest of us. But anyway, yes, there will be more stuff coming up. But it's there. It's like a 2-minute intro video.
Oh.
Yes.
I'm sad. I'm sad to see Levitt make this decision. I don't like it. And Levitt was the first judge, like way back in the beginning of my channel, where we had the drunk lawyer who showed up in court.
Yes, blew a 7.5. Yeah.
I loved those hearings. I absolutely loved those hearings.
That's right. That was her, huh?
Those were fun. And then she was fun during the your go around with Kim Blandino. She was the one who ultimately forced you to be the attorney.
Yes, she would not allow me to withdraw. No,
she was
denied my motion to withdraw. And then we had the oh my goodness. Yeah, and she wanted that trial done. I remember when I was speaking to Mike, the prosecutor, we're like, well, let's see, because it was December, I think, of when we got it. Like, well, let's get past the holidays, and I've got these other things set, and so we're like, Judge, it looks like May. She's like, oh no, that's too far out. So she made us do it in 3 months. Oh dear.
So it's
So,
interesting.
good
So we were in the
times.
middle of this, and you said you know she might take it under advisement. I would think that she would, and I would think that she would, given the profile of this, that she would issue an order, like she would have a clerk work on it and make it good, you know.
Uh-huh.
But she didn't. She just
Like issue a written decision, kind of
issue a written decision. She's
outlining,
just like, nope, I
yeah,
grant the
points
appeal.
and authorities. So, yeah, I don't know.
Yay.
Crazy.
Crazy stuff. All right. Well, now I go. All right. Everybody go over there and give Ben a watch on the new stuff.
Yes.
And there's going to be fun new stuff going on. I'll go over there, I'm sure, and we'll do a stream soon.
Yes.
All right, man. Thanks for coming
All
on. I
right, buddy.
appreciate it.
Yeah.
That was a wild
fun.
one.
This was unexpected. Yeah.
Unexpected. Breaking news here on Let's Talk with Mike.
Yes. Need a breaking news sounder.
I don't care. You know, I don't care. Even if he won. Here's the thing. I still got this out of it. I still got this out of it. So now he's gonna be back at it, just being a complete jackass all over again. Someone
Bigger
will
and
ultimately
bolder.
get hurt by this poor decision.
We'll see.
He's now going to push the boundaries farther. Someone will end up getting hurt.
Well,
That's
let's
my
hope
prediction.
not, but
He had almost learned his lesson, but now
Almost.
you get a dopey judge making a bad decision, and there you go. Now he thinks he's justified in life.
yeah, I'm surprised. I mean, I guess I understand her reasoning, but I just, I was surprised by it, to be honest.
Yeah,
Because
Yeah.
I mean, I think it's, there are legitimate time, place, and manner restrictions on all, on
Yeah.
First Amendment activities. So that's why I thought that would sort of carry the day, but who knows now what'll happen.
It's kind of a bummer because she's been on the bench a long time, and she'll now be known for making this bad decision effectively, and nothing else.
Well,
She's near the
yeah.
end of her career, clearly.
I don't think so. I don't know. She's been on the bench a while, but
Well, I mean, you still might have to be in front of her, so I get it.
well, yeah.
That's
Yeah.
me giving an honest read from Chicago, where I don't care. All right. Thank y'all for
All right.
coming out. I appreciate
All
it. I'll see y'all soon.